We have the jurors here too? Yes. Okay. Let's go on the record.
We're on the record.
State anything before we bring in the jury?
May we approach this very briefly, Judge?
Sure. Do you want me to turn the sidebar music on?
Sure.
For the jury? You may be seated. You have heard all the evidence. It is now my duty to tell you the law that you must follow in this case. The law governing this case is contained in these instructions that I am about to give you. It is your duty to follow the law as contained in these instructions. You must consider these instructions as a whole. You must not pick out one instruction or parts of an instruction and disregard others. A copy of these instructions will be given to you when you begin your deliberations. The law presumes the defendant to be innocent unless and until you are satisfied beyond a reasonable doubt of his guilt. The burden is always on the state to prove guilt beyond a reasonable doubt. It is not required that the state prove guilt beyond all possible doubt. The test is one of reasonable doubt. A reasonable doubt is a doubt based upon reason and common sense. The kind of doubt that would make a reasonable person hesitate to act in the graver and more important affairs of life. You are the sole judges of the facts in this case. It is your duty to determine the facts from the evidence produced here in court. Your verdicts should not be based on speculation, guess, or conjecture. Neither sympathy nor prejudice should influence your verdict. You are to apply the law as stated in these instructions to the facts as you find them, and in this way decide the case. You must not concern yourself with the consequences of your verdict. You must not draw any inference of guilt from the fact that the defendant did not testify in this case, nor should this fact be discussed by you or enter into your deliberations in any way. You alone are the judges of the credibility of the witnesses and the weight to be given to the testimony of each of them. In determining the credit to be given any witness, you should take into account the witness's truthfulness or untruthfulness, ability and opportunity to observe, memory, manner while testifying, any interest, bias, or prejudice the witness may have, and the reasonableness of the witness's testimony considered in the light of all the evidence of the case. You should consider each opinion received in evidence in this case and give it such weight as you think it deserves. If you should conclude that the reasons given in support of the opinion are not sound, or that for any other reason an opinion is not correct, you may disregard the opinion entirely. An expert witness is a witness who, by knowledge, skill, experience, training, or education, has become an expert in any subject. An expert witness may be permitted to state an opinion as to that subject. You should consider each expert opinion and the reasons stated for the opinion, giving them such weight as you think they deserve. You may reject an opinion entirely if you conclude that it is unsound. Evidence has been admitted concerning a statement allegedly made by the defendant. Before you consider such statement for any purpose, you must determine that the statement was given voluntarily. In determining whether a statement was voluntarily given, you should consider if it was freely made and not induced by promise or threat. Each crime charged in the indictment should be considered separately. For you to find the defendant guilty of first-degree murder by a deliberate killing as charged in count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant killed Jacqueline Vigil. The killing was with the deliberate intention to take away the life of Jacqueline Vigil. This happened in New Mexico on or about the 19th day of November 2019. A deliberate intention refers to the state of mind of the defendant. A deliberate intention may be inferred from all of the facts and circumstances of the killing. The word deliberate means arrived at or determined upon as a result of careful thought and the weighing of the consideration for and against the proposed course of action. A calculated judgment and decision may be arrived at in a short period of time. A mere unconsidered and rash impulse, even though it includes an intent to kill, is not a deliberate intention to kill. To constitute a deliberate killing, the slayer must weigh and consider the question of killing and his reasons for and against such a choice. An issue you must consider in this case is whether the defendant was intoxicated from the use of alcohol or drugs. You must determine whether or not the defendant was intoxicated from the use of alcohol or drugs, and if so, what effect this had on the defendant's ability to form the deliberate intent to take away the life of another. The burden is on the state to prove beyond a reasonable doubt that the defendant was capable of forming a deliberate intention to take the life of another. If you have a reasonable doubt as to whether the defendant was capable of forming a deliberate intent to attempt to take away the life of another, you must find the defendant not guilty of first-degree murder by deliberate killing. For you to find the defendant guilty of second-degree murder as charged as an included offense in count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant killed Jacqueline Vigil. The defendant knew that his acts created a strong probability of death or great bodily harm to Jacqueline Vigil. This happened in New Mexico on or about the 19th day of November 19, 2019. Great bodily harm means an injury to a person which creates a high probability of death or results in serious disfigurement or results in loss of any member or organ of the body and results in permanent or prolonged impairment of the use of any member or organ of the body. You have been instructed on the crimes of first-degree murder by deliberate killing and second-degree murder as charged in count 1. It is up to you, the jury, to choose the manner and order in which you deliberate on the crimes charged. However, to return a verdict, you must follow the procedure described in the next instruction. To aid you in your deliberations and in returning your verdict, you will be provided both guilty and not guilty verdict forms for each of the crimes charged in count 1. Unless you unanimously agree on a verdict, you should not sign a verdict form for that crime. Although you may deliberate on the crimes charged in count 1 in any manner and order in which you choose, you must return your verdict for each offense in count 1 in the order they are instructed. Under this procedure, if you unanimously find the defendant guilty of first-degree murder by a deliberate killing, you should sign the guilty verdict for that offense and should not proceed to reach a verdict on the remaining offense. If, after reasonable deliberation, you do not reach a unanimous verdict on first-degree murder by a deliberate killing, you should not sign a verdict form for that offense and should not proceed to reach a verdict on the remaining offense. You should only return a verdict on second-degree murder if you unanimously find the defendant not guilty of first-degree murder by a deliberate killing. If you unanimously find the defendant not guilty of first-degree murder by a deliberate killing, you must sign the not guilty verdict form for first-degree murder by a deliberate killing before returning a verdict on any other crime as charged in count 1. If you unanimously find the defendant guilty of second-degree murder, you should sign the guilty verdict for that offense and should not proceed to reach verdicts on the remaining offense. If you do not reach a unanimous verdict on second-degree murder, you should not sign a verdict form for that offense. If you unanimously find the defendant not guilty of second-degree murder, you must sign the not guilty verdict form for second-degree murder. For you to find the defendant Luis Talamantes-Romero guilty of felony murder, which is first-degree murder, as charged in the alternative to count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant Luis Talamantes-Romero committed or attempted to commit the crime of aggravated burglary with a deadly weapon or armed robbery under circumstances or in a manner dangerous to human life. Luis Talamantes-Romero caused the death of Jacqueline Vigil during the commission of or attempt to commit aggravated burglary with a deadly weapon or armed robbery. Luis Talamantes-Romero intended to kill or knew that his acts created a strong probability of death or great bodily harm. This happened in New Mexico on or about the 19th day of November 2019. For you to find the defendant guilty of aggravated burglary with a deadly weapon as charged in count 2, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant entered an attached garage without authorization. The defendant entered the attached garage with the intent to commit a theft once inside. The defendant was armed with a firearm. This happened in New Mexico on or about the 19th day of November 2019. For you to find the defendant not guilty of aggravated burglary with a deadly weapon as charged in count 3, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant entered a vehicle without authorization. The defendant entered the vehicle with the intent to commit a theft once inside. The defendant was armed with a firearm. This happened in New Mexico on or about the 19th day of November 2019. If you find the defendant guilty of second-degree murder and aggravated burglary, then you must determine if the crimes were committed with the use of a firearm and report your determination. You must complete the special form to indicate your finding. With respect to any crime, for you to make a finding of yes, the state must prove to your satisfaction beyond a reasonable doubt that the crime was committed with the use of a firearm. For you to find the defendant guilty of conspiracy to commit aggravated burglary with a deadly weapon or tampering with evidence as charged in counts 4 and 7, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant and another person, by words or acts, agree together to commit aggravated burglary with a deadly weapon or tampering with evidence. The conspiracy alleged in this count must be separate, distinct, and not a continuation of count 4 and 7. The defendant and the other person intended to commit aggravated burglary with a deadly weapon or tampering with evidence. This happened in New Mexico on or about the 19th day of November 2019. The defendant, Luis Talamantes-Romero, is charged in counts 4 and 7 with 2 separate conspiracies. Each of these counts requires a separate verdict and must be considered separately. For you to find the defendant guilty of 1 or more conspiracies, as charged in counts 4 and 7, the state must prove to your satisfaction beyond a reasonable doubt that the defendant entered into an agreement to commit the crime alleged in that specific count. It is not enough to return a verdict of guilty on a particular count for you to find the defendant is guilty of some other conspiracy count or entered into some other agreement to commit a crime not charged in that specific count of the indictment. Each conspiracy count must be considered separately. Each verdict of guilty must be supported by evidence, beyond a reasonable doubt, of a separate and distinct agreement to commit the crime alleged in that specific count and not a continuation of counts 4 and 7. Otherwise, you must find the defendant not guilty of that count, regardless of your verdict on other counts of the indictment. If you conclude that the defendant conspired and agreed to commit more than one crime, to assist you in determining whether the defendant entered into 2 or more separate agreements with different criminal objects, or whether the defendant entered into only a single conspiracy agreement to commit multiple crimes, you may consider all of the evidence and the totality of the circumstances. If you find the defendant guilty of conspiracy as charged in counts 4 and 7, then you must determine which crimes the defendant conspired to commit. You must complete the special form to indicate your findings. With respect to each question, for you to make a finding of yes, the state must prove to your satisfaction, beyond a reasonable doubt, that the defendant conspired to commit the crime of aggravated burglary and or tampering with evidence. For you to find the defendant guilty of an attempt to commit the crime of armed robbery as charged in count 5, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant intended to commit the crime of armed robbery. The defendant began to do an act which constituted a substantial part of the armed robbery, but failed to commit the armed robbery. This happened in New Mexico on or about the 19th day of November 2019. The essential elements of armed robbery are: the defendant took and carried away a Cadillac vehicle or items in a Cadillac vehicle from Jacqueline Vigil or from her immediate control, intending to permanently deprive Jacqueline Vigil of the Cadillac vehicle or items in a Cadillac vehicle. The defendant was armed with a gun. The defendant took the Cadillac vehicle or items in a Cadillac vehicle by force or violence or threatened force or violence. This happened in New Mexico on or about the 19th day of November 2019. For you to find the defendant guilty of tampering with evidence as charged in count 6, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant changed, hid, or placed a Jeep Cherokee vehicle or parts from a Jeep Cherokee vehicle and or changed, hid, or placed a firearm or firearm parts. By doing so, the defendant intended to prevent the apprehension, prosecution, or conviction of himself for the crime of first-degree murder by a deliberate killing, second-degree murder, felony murder, aggravated burglary, attempted armed robbery, and larceny. This happened in New Mexico on or about the 19th day of November 2019. You must complete the special verdict form to indicate your findings and report your determination. For you to find the defendant guilty of larceny as charged in count 8, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant took and carried away a vehicle wheel belonging to another, which had a market value of under $250. At the time he took this property, the defendant intended to permanently deprive the owner of it. This happened in New Mexico on or about the 19th day of November 2019. The defendant may be found guilty of a crime even though the defendant did not do the acts constituting the crime if the state proves to your satisfaction beyond a reasonable doubt each of the following elements. The defendant intended that another person commit the crime. Another person committed the crime. The defendant helped, encouraged, or caused the crime to be committed. This instruction does not apply to the charge of felony murder. The defendant, Luis Talamantes-Romero, may be found guilty of felony murder as charged in the alternative in count 1, even though the defendant did not commit the murder, if the state proves to your satisfaction beyond a reasonable doubt each of the following elements. The defendant, Luis Talamantes-Romero, intended that another person commit the felony of aggravated burglary with a deadly weapon and or attempted armed robbery. Another person committed the felony of aggravated burglary with a deadly weapon and or attempted armed robbery under circumstances or in a manner dangerous to human life. The defendant, Luis Talamantes-Romero, helped, encouraged, or caused the felony of aggravated burglary with a deadly weapon and or attempted armed robbery to be committed. During the commission of the felony of aggravated burglary with a deadly weapon and or attempted armed robbery, Jacqueline Vigil was killed. The defendant, Luis Talamantes-Romero, helped, encouraged, or caused the killing to be committed. The defendant, Luis Talamantes-Romero, intended the killing to occur or knew that he was helping to create a strong probability of death or great bodily harm, and this happened in New Mexico on or about the 19th day of November 2019. In addition to the other elements of second-degree murder, felony murder, aggravated burglary, tampering with evidence, and larceny, the state must prove to your satisfaction beyond a reasonable doubt that the defendant acted intentionally when he committed the crime. A person acts intentionally when he purposely does an act which the law declares to be a crime. Whether the defendant acted intentionally may be inferred from all of the surrounding circumstances, such as the manner in which he acts, the means used, his conduct, and any statements made by him. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agrees. Your verdict must be unanimous. It is your duty to consult with one another and try to reach an agreement. However, you are not required to give up your individual judgment. Each of you must decide the case for yourself, but must do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own view and change your opinion if you are convicted it is erroneous, but do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the purpose of reaching a verdict. You are the judges of the facts. Your sole interest is to ascertain the truth from the evidence in this case. In this case, there are two possible verdicts as to each crime charged, guilty and not guilty. Only one of the possible verdicts may be signed by you as to each charge. If you have agreed upon one verdict as to each particular charge, that form of verdict is the only form to be signed as to that charge. The other form as to that charge is to be left unsigned. And I actually need to speak to the attorneys, so with the bench conference. The attorneys will now argue the case. The state will go first, followed by the defense attorney, followed by the state again. State, closing argument.
Thank you, Judge. May it please the court and counsel. Test. 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 Yeah. Test. Test. Let's try the other one. That's better. Can you hear me still? Okay. Thank you again, ladies and gentlemen, for your patience and your consideration and your attention in this matter over the last several days. You just heard an enormous amount of jury instructions, and it probably seemed a little overwhelming. I'm going to unpack those now and hopefully help you understand them a little bit. And then I'm going to get into the meat of my argument. It's going to take a minute, so bear with me. First and foremost, I want to give you what I call cheat codes. My sons like to play video games, and they like to get into cheat codes to advance themselves in the game. This is your cheat code, so I'd ask you to pay attention. So, particularly with first-degree murder and felony murder. Now, what we're doing here is we're presenting to you two different theories. As Ms. Staley pointed out, if you recall, during voir dire, we talked about if you're able to follow the law and the jury instructions and have two different theories, or be able to sort of wrap your head around the idea that we can present two different theories of murder that get us to a similar place. Like in science, you'd have maybe two different theorems on an experiment. So we have first-degree murder by willful and deliberate intent, and then we also have felony murder, which is the commission of a murder during the course of a dangerous felony. These are our two different theories. And when I say cheat codes, what I'm telling you is your instructions are all numbered. You're all going to get packets of instructions to review and to help in your deliberations and to guide you. And these instructions are numbered. So I'm going to just give you the numbers on these jury instructions that apply to first-degree murder and then the ones that apply to felony murder. And then we'll move on from there. So first-degree murder, instruction 12, 13, 14, 15, 16, 17, and 21. Those apply to murder 1, or first-degree murder, willful and deliberate. Felony murder is instruction 18, 19, 25, 29, and 30. Now, having said that, there is, as I said before, two different theories that we're going for first-degree murder. We're going for felony murder, that is whether the defendant committed murder while in the commission of either an aggravated burglary or an attempted armed robbery. So you can pick one or both. It doesn't really matter when you're finding felony murder, but it's basically you commit a dangerous felony, you kill someone in the process. It's second-degree murder plus a dangerous felony. That's cheating and getting our way to, this is law school, like law school for dummies, right? I mean, I'm not calling it dummies, but this is like the fast way to get there. So with regard to the Lewis instruction, which is instruction number 17, we call it the Lewis instruction. It's based on an older case. This is the one that applies to murder 1. And this is a little bit of a difficult instruction to kind of wrap your head around if you've never seen it. And what it talks about, I'm going to deviate from the podium, you can still hear me, is when considering murder and a lesser included of second-degree murder, okay, which is a subset of first-degree murder, this instruction tells you how to deliberate on that. So you can consider first-degree murder or second-degree murder on those instructions in any order you want, right? So you can look at it, you can think about the facts in any order you want. When it comes time to deliberate, though, when it comes time to deliberate and start casting your vote or however you're going to make your decision, you need to consider first-degree murder first, right? And this is, again, only for first-degree murder instruction 12. So here's how you look at it. First-degree murder is this big circle, right? And you deliberate on first-degree murder first. If you decide that the defendant committed first-degree murder, we're going to color in the entire circle. And you're done. You don't have to go deliberate on second-degree murder because that's an included offense. It falls within that circle of first-degree murder. And you've already colored it in. Is everybody with me? However, if you decide that the defendant did not commit first-degree murder by a willful and deliberate intent, then you go to second-degree murder, which is a circle inside that first-degree murder circle. And you deliberate and you vote on that and you make a determination, did he commit second-degree murder? And if you did, you only color in that inner circle. Does that make sense? I'm a visual person, so that's the best way it makes sense to me. So that's how you treat instruction 17. Okay. Next, I want to talk really briefly about instruction number 20, which is the aggravated burglary instruction. Because it's a little bit vague, but I want to make sure that it's clear. This is for the aggravated burglary with a deadly weapon of the Cadillac Escalade at the Mesa Ridge Apartments. Okay? So there's a couple of aggravated burglary charges and instructions that are included in here. There's the aggravated burglary that we're alleging occurred at Corte de Loma at Jackie Vigil's house. That's one aggravated burglary. But there's a second aggravated burglary that happened before that at the Mesa Ridge Apartments, and that's the one that applies to instruction 20 because it doesn't really give much clarity on that in the instruction itself. So I want you to remember that. Next, I want to talk about instruction 25. And again, this is like a quick and dirty law school class, so just bear with me. So instruction 25 is our instruction for an attempted armed robbery. And you'll note that the actual instructions that you're to follow or that you're to deliberate on are marked 1, 2, and 3 at the top. So the defendant intended to commit a crime of armed robbery. The defendant began to do an act which constituted a substantial part of armed robbery but failed to commit the armed robbery. And 3, this happened in New Mexico on the 19th day of November 2019. And then below that, on the same page, right here, you actually have the elements of armed robbery. So this is sort of like a theoretical armed robbery that you have to consider and understand in order to understand whether the defendant attempted to do those first 3 elements. Does that make sense? So this is like the hypothetical armed robbery because clearly, I mean, the defendant took the Cadillac vehicle or items in the Cadillac vehicle by force, violence, or threatened force, violence. We've heard in facts that they didn't take from that Cadillac in the garage. They fled. The only thing they took was a life. And then finally, the tampering instruction. Let me get there. Oh, I'm sorry, I skipped ahead. Trying to find the instruction. I should have written it down. Oh. I'd lose my head if it wasn't attached to my shoulders sometimes. Okay, instruction 23. This is for the conspiracy theories. This basically just guides you on how to handle your conspiracies. Whether or not you have to make a determination as to whether there was conspiracy between Luis Talamantes-Romero and Isaac Ramirez on the aggravated burglaries and attempted armed robberies at the 2 separate locations, or whether it was just one general conspiracy. It's a little convoluted, and I would encourage you to read through it, but that's instruction 23 and 24 basically tell you how to make that determination or guide you on how to make that determination. And it's ultimately up to you factually as to whether you think they conspired to commit both one or the other separately, or how you're going to make that determination, and which crime they actually conspire to, if any. Okay? So 23 and 24 deal with that specifically. All right. That part of the class is over. And now I want to get into the meat and potatoes of our case. This is the facts. I mean, we've gone through the law. That's the law that you are charged with following, but let's get into the facts. And I want you to recall and go back to when we started this case and my opening statement. Everything in my opening statement we have delivered to you. I want to be clear about that. Everything that I told you in opening statement, we have proved beyond a reasonable doubt. So here we are. On November 19th of 2019, Luis Talamantes-Romero murdered Jacqueline Vigil in the early morning at her home at 2116 Corte de Loma, right? We've established that clearly and beyond a reasonable doubt. And what we're going to focus on first is the physical evidence. Now, again, going back to our jury selection process, we talked a little bit about physical evidence and circumstantial evidence and direct evidence and all those different kinds of evidence. Now, your job, now that you've received that evidence, is to weigh that evidence. You're where the rubber meets the road. You are weighing the evidence and determining whether or not we have proved, and I submit to you, we have proved, beyond a reasonable doubt, of the defendant's guilt. So what do we have as far as physical evidence? Shell casings, the Jeep Cherokee wheel, and the jail calls. Yes, the jail calls are physical evidence, in my opinion. It's not testimonial evidence of somebody on the stand, but it's actually the defendant's own voice speaking to you. And physical evidence, ladies and gentlemen, I would submit to you also, in this case, is like circumstantial evidence, right? You remember, again in voir dire, the allegory of the snow is the way I call it, right? You go to sleep one night, it's cloudy, maybe kind of cloudy like it is tonight. It gets real damp, temperature drops. But when you go to sleep, not a single snowflake has hit the ground. But it feels like it's going to snow. You wake up the next morning, and there's a fresh sheet of snow over the entire city. Right? You never saw a single snowflake hit the ground. But when you wake up, you know it's snow. A very, very basic example of circumstantial evidence to show that it's snow. That's what we have here, right? Just looking at this evidence by itself, we have circumstantial evidence to show that Luis Talamantes-Romero committed this murder on Jacqueline Vigil. The shell casings. That's perhaps one of our strongest pieces of evidence. Right? The first shell casing was located in the garage there at Corte de Loma. The other shell casing, because of sloppiness or dumb luck or whatever you want to call it, was at that home on Pacific, the Talamantes home. Right? We saw this image in opening. These are our two casings where they came to rest at their respective locations. You remember Jill Prather? She talked at length about how she did that comparison. And it's not just an eyeball test comparison, but she looked at these things under a microscope. She looked at the shearing. She looked at the tool marks and the impacts that these weapons made, or that this weapon made on these two casings. And she determined that it came from the same weapon, and more importantly, the type of weapon that it came from, which I believe was a Smith & Wesson 40, an MP40 is what she described it as, right? And that was by process of elimination. She was able to take these casings, looking at the tool marks, looking at the projectile that was taken out of Jackie's body, and comparing all of these things, and using her knowledge and expertise, and studying them very closely, determined that these were a match. The Jeep Cherokee, right? This is probably equally as important. And here's why. First, if we're doing this as a logical exercise, we're going to assume that the statements that Sam Vigil made in his 911 call were the truth, right? They were like what we call in the law an excited utterance, or a present sense impression. They have an indicia of reliability, or they carry the truth with them because of the way that they're made, the way that these statements are given. He's perceiving the event as it's occurring for him, right? And remember what he said in the 911 call.
Hello, hi, what's going on? Somebody shot my wife. Please call the police. Did it come through the wall? How did it happen? No, she was driving her car out of the garage. I saw a Jeep she going to the gym. She was leaving. When I heard my car honking, I went out there and there was a Jeep that took off. I didn't know what was going on, but I can't get in the car because, it flopped. She's in the car. All right, so is it in the garage or in the driveway? It's in the driveway, yeah. Okay. Please send the police and the...
Yeah, I've got it. I've got it coming. You saw a Jeep that came through, or?
It was a Jeep, because I heard the honk of the car. So I went outside to see what had happened. I thought, well, maybe she forgot something. And when I got out there was a Jeep backing up and took off really fast around the corner.
What color was it?
It looked like a brown Jeep to me.
Okay.
But that's all I could see.
And did it go to the left or the right when it left out of your street?
It went out to the left.
To the left?
Okay. Yeah. Please hurry up, okay?
What do we have? Well, let's start with, and you'll see it in a minute. If you recall Officer Carvajal's testimony, and you recall Officer Carvajal's lapel video that we watched, right? We heard her say, oh, that's weird, there was a brown Jeep at this other location on the west side that just happened. So what officers do, they went and pulled that surveillance video and talked to those witnesses who you also heard from today, or during the course of the week, excuse me. And you saw that image of the Jeep, right? Think about that with regard to what Sam told you. Not only that, we heard Commander Hartsock testify about how he was able to pull this image off of Luis Talamantes' Facebook page. Guess what? That's the same Jeep. Guess what's different? The wheels, the rims, right? Now, I would submit to you, if you're going to commence a night or early morning of hell raising, such as what we've heard about during the course of this trial, are you going to ride around with those rims, or are you going to ride around with those rims? What's more identifiable? Those rims or those rims? And in fact, I would submit to you also, if you recall on the jail calls, they talked about those rims, changing those things out, because those are very distinguishing. Can't miss those. Those are pretty. Those are just basically. And there's our Jeep at the Pacific address, right? This is Elizabeth Talamantes' pad house. And that's the dirt lot in the alleyway, not on the street, but in the alleyway, under trees, between houses, and under a tarp, which we learned later, and disassembled, and with those nice rims on again. And guess which parts are disassembled? That front fender of the Jeep, right? Just by the physical evidence alone, it's starting to stink. It's starting to smell real bad for the defendant. We heard that Elizabeth Talamantes called law enforcement to turn that Jeep over. Let's talk about that wheel. There it is. This, when I was thinking about this case as we were progressing through trial, I was reminded of the story of Hansel and Gretel, right? You remember Hansel and Gretel, the nursery rhyme story? And how Hansel and Gretel were taken to the witch's cottage in the woods, and in order to be rescued or whatever, they dropped breadcrumbs, right? And then the birds came and ate the breadcrumbs, so eventually they would drop pebbles that the birds would eat. This is our breadcrumb, or maybe our better analogy, this is our pebble, right? This is a piece of evidence that directly goes with that Jeep. We heard from Isaac talking about how that rim was cracked. We have a cracked rim right there. And we have the jail calls. let's shift gears to that.
¿Qué rollo? No, pues nomás saludarla porque tú sabes, pues les digo que yo lo necesito mucho yo. Pues sí, pasó, lo que pasó, ni pedo, pero pues espero llevar a aquel güey porque aquel güey trae una pinche bocota.
Pero pues, todo no tenía que pasar, ¿no? Eso tenía que pasar, pues, y pues...
Era bien conocido.
No, porque...
Porque ahorita miré en la pantalla, nomás andan buscando un
No
escritor.
La baja.
Nomás necesitan, pues tú sabes, pues Julio, tú sabes más que yo, tú ya sabes todo, nomás que necesitaba que hablara bien con aquel güey, con el patracross, que no voy a andar de pinche sifón.
Ahora te voy a hablar por el patrón y no que vente lado, porque está pasando.
Ya, nomás que estaban los dos, ¿o qué?
Sí, güey.
No, tú no te agüites, todo está bien, yo aquí miré, la pantalla, todo está bien, no hay nada, nomás andan sobre, ya sabes, nomás necesito nomás necesito que andes al 100, ya aquí la luna doctora, y esa de vernos, espero de que lloren en su casa, de que lloren en la mía.
No. Pero la promoción, mi transmisión, ¿quién era?
Nomás por a nadie se les ocurre, ¿no? Nadie.
No sé.
Era un cabello negro, ¿no?
Sí.
Ya. No, tú nomás esa de ganas y no te tiro, nomás necesito que andes así, no andes tomando ya, güey, yo necesito que andes así.
No, estoy.
De todo modo, con el favor de Dios me dejen salir tarde que temprano, pero no, tú no te agüites.
Oye, acá, la noche está. Pero no se atrás,
Ya. Aunque no hayan entendido marcas esa madre, ¿no?
no, si también, si también,
Ay. Pues neta, nomás que andes a tiro, no te me agüites tú, échale ganas.
no, pues ya tu paseo, ya está hecho, ya ayudando, pues, ya está.
No, todo chido, nomás tú no te agüites. Y tú como hacer muchas ganas, todo va a estar chido con el favor de arriba. No te me agüites, échale ganas, no. Te quiero mucho, échale ganas, yo. No te me agüites, así como tú me enseñaste siempre que no me agüitara, que me dieron ahorita que para. No te me agüites, Ángel, como siempre me has dicho. Que me den un mes con su estómago porque tú sabes. no.
Yo sé. Las tardes, tú. Las tardes.
O sea, de ganas, no sé, ahorita no me gustaría estar así. Yo sé que está cabrón y todo, pero si prefiero que va a pasar algo y yo saliendo ya sabes que yo voy a estar allá, date la vuelta y todo, vas a ver con el cabrón, todo va a estar chido.
You have 1 minute remaining.
Ahí les marco para atrás en unos 15 minutos suyo. Entonces, te quiero mucho, no te quiero. Sé que te quiero mucho. Bueno, bye.
Thank you for using Global Tel-Link.
That's one of several calls that you'll be able to take back with you. I would encourage you, if you want to, listen to them as you deliberate on them. Rely on your memory as you heard them in court. But there's a lot of nuggets in that call, right? There's a lot of admissions in that call. And I can guarantee you the defendant's not crying for Jacqueline Vigil. He's crying for himself. As he said, he fucked up. Pardon my French. He is only concerned about himself in that call. And so that, along with the other calls, I pulled out some snippets for you to consider. They have to get out of there, right? They have to get rid of that truck. Or cabeza de hacha, which is they're talking about Isaac. Cabeza de hacha is like, it's like blockhead, right? Like dummy. I fucked up, fool. Was it someone we knew? No, it was no one. It was no one. They're looking for a description on the screens, on the television. Have a good talk with Pata de Cruz. You know, pigeon foot. Keep him from blabbering. Get rid of all the craziness. I did not even know her, fool. Did she have black hair? Yes. Those are all snippets and admissions. Even though they tried to talk in code, when you look at it in the totality of all of the evidence that you have in front of you, that's the defendant telling you he committed this murder. Let's get back to jury instructions for just a minute, because this is important. Willful and deliberate murder. For you to find the defendant guilty of first-degree murder by deliberate killing as charged in count 1, the state must prove to your satisfaction and beyond a reasonable doubt each of the following elements of the crime. 1, the defendant killed Jacqueline Vigil. 2, the killing was with the deliberate intention to take away the life of Jacqueline Vigil. And 3, this happened in New Mexico on or about the 19th day of November. It seems simple enough when you look at those 3 elements that we have to meet. But then we have this guy right here, which follows, and you'll have a copy of this. A deliberate intention refers to the state of mind of the defendant. A deliberate intention may be inferred from all of the facts and circumstances of the killing. The word deliberate means arrived at or determined upon as a result of a careful thought and the weighing of the consideration for and against a proposed course of action. So let's start with that portion first. Every time I read that, and maybe just because I'm Gen X, I don't know, I think of like the cartoons where you have a little devil on one shoulder and a little angel on the other shoulder, and they're each fighting over the decision the person has to make, the little cartoon character. It doesn't work like that. That's how it feels like it's described, but it doesn't necessarily work like that. What we are charged with doing, ladies and gentlemen, is getting into the mind of the defendant. We have to crawl into the mind of the defendant. It's not a fun exercise, but it's a necessary exercise under this instruction. A calculated judgment and decision may be arrived at in a short period of time. A mere unconsidered and rash impulse, even though it concludes an intent to kill, is not a deliberate killing. To constitute a deliberate killing, the slayer must weigh and consider the question of killing and his reasons for and against such an action. Now, it would seem on its face that maybe this was just a rash impulse, right? Because you heard the testimony that Talamantes approached Jackie's car in the garage, had her at gunpoint. She honks the horn and then the gun goes off, right? It was very, very close in time. In fact, so close that Sam testified that he didn't even hear the gunshot. Maybe that's a mere unconsidered and rash impulse. But it's not. It's not, and here's why. One is a calculated judgment and decision may be arrived at in a short period of time. So let's think about this. What's going on in his mind? Premeditation begins at the Mesa Ridge Apartments. It continues to Corte de Loma, and it doesn't have to be prolonged. What does he do at the Mesa Ridge Apartments? Right? What did we hear? So he's breaking into a car, right? And he gets busted. And so he says, dame la cuete, right? Or give me la cuete. And he gets the gun. And I think we heard David Castro's testimony was that he actually pointed it at him. But he didn't fire. Because what did David Castro do? And his significant other? They backed away, right? They didn't get in Luis Talamantes' way. They actually fled back into the apartment to safety and called police, which allowed the defendant to continue doing what he wanted to do, which was take those things from that Cadillac. What did he do to achieve that end? He used a weapon intended to commit murder, right? Intended to commit death. That's what a gun is for. Let's not fool ourselves. Whether it's for protection or offense, it's meant to kill it. When they get to Corte de Loma, they pull into that cul-de-sac. They park at a distance, and Luis sees the garage door open at that point in the early morning, right? Then they pull closer. What does he do at that point? When he's like, I'm gonna go get that. Either he's gonna go rob the garage, rob the car, rob Jackie in some way, shape, or form. And Isaac says, no, don't do that. Luis pulls away. He chambers around in his firearm, which means it's ready to go, right? All you got to do at this point is pull the trigger. He has a live round in the chamber. He points it now at Isaac and says, don't tell me what to do. Right? Now we're entering into the mind of the defendant. We're creeping into that head of his. Don't tell me what to do. And he looked at him. He gave him a look. And he made his way over to Jackie's vehicle. He held her at gunpoint and at close range. So, what do we know, right? We know the garage. We've seen photos of the garage. He's very, very close to Jackie Vigil's car. He has to have that firearm out. We've heard testimony that it was already out from Isaac. We know, based on the physical evidence and that circumstantial evidence that we discussed, he has it out. He has her at gunpoint, ladies and gentlemen, and here's why I submit to you that that's the case. Hold on a minute. And we'll get to this a little bit more as I go through my argument, but if you recall, first of all, the trajectory, just based on Detective Ortiz's testimony, that was a direct shot into that car, right? You also saw the images of Jackie, the way she came to rest, and where the bullet hole was, right? And we heard from Olamai that it was left to right in a downward trajectory, and she was slumped over this way. It suggests that she saw the gun, she honked and braced almost simultaneously at the point that she was murdered. That's deliberate intent arrived at in a short period of time, or a prolonged period of time, if you will, if you consider that this is his course of action throughout the course of this entire morning. You get in his way and you die. You get in Luis Talamantes' way, and you die. You heard that from David, from Michaela, and we saw it with Jacqueline Vigil. Now, let's talk about second-degree murder, because second-degree murder is part of felony murder. Again, felony murder is basically second-degree murder combined with a dangerous felony. The defendant killed Jackie Vigil. The defendant knew that his acts created a strong probability of death or great bodily harm to Jacqueline Vigil, and this happened in New Mexico on the 19th day of November. That's very, very basic. That's very easy to get to. He just has to know that his acts created a strong probability of death or great bodily harm. I would submit to you, yes, his acts did constitute that, but it also constituted a willful and deliberate action. For you to find the defendant, as far as felony murder goes, for you to find the defendant guilty of felony murder, which is first-degree murder, is charged as the alternative to count one. So again, we're talking about separate theories. The state must prove to your satisfaction and beyond a reasonable doubt that, one, the defendant, Luis Talamantes-Romero, committed or attempted to commit the crime of aggravated burglary or armed robbery. You can pick one, you can do both. It's up to you. He did this under a manner or circumstances dangerous to human life. We know that. He held her at gunpoint. He caused the death of Jackie Vigil during the commission of the aggravated burglary or the armed robbery. He intended to kill or knew that his acts created a strong probability of death, which is that second-degree murder instruction. They basically took that and moved it right into this one for you. And this happened in New Mexico on the 19th day of November. So this is the instruction on the attempted armed robbery I was telling you about. So again, your job is to follow the first four and rely upon the second four as a guide to determine whether or not he took substantial steps in completing that armed robbery. Aggravated burglary. Now this is important. This is actually more intricate than maybe you think it is. Or maybe you understand where I'm getting at already because you followed the evidence. Aggravated burglary constitutes the following. The defendant entered an attached garage without authorization. The defendant entered the attached garage with the intent to commit a theft once inside. The defendant was armed with a firearm, and this happened in New Mexico on or about the 19th day of November 2019. In order for an aggravated burglary to apply here, the defendant under element number 1 must have entered the attached garage without authorization, right? And we didn't hear that from Isaac, but we do have that physical evidence. The question for you is whether or not he crossed that threshold in that garage to constitute a burglary. If you didn't cross the threshold, you might have an attempted armed robbery, but you don't have that attempted burglary. However, I would submit to you, and we went through this painstakingly, he did cross that threshold. Let's look at that picture again. And you'll have it to take back with you. You have all those photos, and I want you to pore over them carefully. Look where that shell casing came to rest, right? Not only looking at that shell casing and where it came to rest, consider the lapel video that we watched. And we'll watch it again in just a minute. But consider how that shell casing came to be there. And as soon as it was noticed, how it was treated by law enforcement and by Sam and anybody else who was in that garage, right? They didn't kick that shell casing. They didn't move that shell casing. They didn't step on that shell casing. And that shell casing, I think the testimony was at least 5 feet in from the garage. Okay? So that's one thing there. Also, going back to what Detective Ortiz testified about, what she told you, and combined with Ms. Prather, what she told you, the ejection pattern for a Smith & Wesson 40 MMP is to the right, right? So, what do we know? This is our impact. Ortiz told us that the impact angle was direct. It was not glancing, right? That's a pretty cylindrical hole that we're looking at. It's not oval shaped or oblonged. And this is a little bit graphic, the next picture. Bear with me, please. This is how Jackie came to rest, right? And we heard from OMI that that was to the left, from the left to the right and downward, suggesting that she had at least the wherewithal to turn away before she was murdered. There's sort of an overall image of that same shot. Talking about trajectory, right to left and downward. Thinking about now, I want you to consider ejection pattern. If you've stored that and locked that away, let's go back to this scene again. All right, what did Detective Ortiz say? She says that she posits, based on all of this physical evidence, that the defendant was likely standing next to that black trash bag that we see in that image. Right? Ejection patterns to the right. So you're firing it at close range. It's really difficult to even hold it sideways. It would most likely have to be this way in order to get that shot off. It's going to go out that way. If he was standing any closer to the threshold of the garage, it may have ended up in the driveway itself, but it didn't. It is squarely inside that garage and undisturbed from the point that it was ejected from that firearm. So, using your common sense and understanding of the combined testimony of Detective Ortiz and Ms. Prather and Dr. Jarrell, it all tells you that he was inside that garage. That gets you back to the aggravated burglary. He entered in to commit a theft, right? What else is he going to do? He's probably going to take that Cadillac. He's probably going to take the Cadillac. His attention may have been gotten when he saw the first Cadillac parked in the driveway. It was a bonus for him in his mind when he sees the garage door opening. And he sees Jackie pulling out, because now it's started. He doesn't have to mess with anything to get that. It's right there for the taking. And if you get in his way, you die. Attempted armed robbery. Going back to that again. We knew that they had been up to no good all night. They burglarized a Jeep, stolen the wheel off another Jeep. We know that he saw that opportunity. Had this ended differently, he may have just ended up taking the vehicle at gunpoint. This is an attempted armed robbery because, again, they started it. The commission of it was almost carried through, but they didn't end up taking anything away, except for themselves and the life of Jackie Vigil. But no physical items were in their possession. Okay, I think I've exhausted the physical evidence about as much as I can for you, so bear with me, please. Next, I want to talk about the credibility of witnesses. Because even though we do have a lot of physical evidence, this case is still very much predicated on the credibility of the witnesses and the weight that you're to give them as they testify to you. And this is one of the instructions that you have. I forget which number it is, and I'm not going to thumb through all my instructions again, but I want you to focus on the last part of that instruction. I want you to accept the instruction entirely, but for purposes of my argument, that last sentence really sticks out to me. The reasonableness of the witness's testimony considered in the light of all of the evidence in the case. What this tells me, and what this should tell you, ladies and gentlemen, and we went through this in voir dire, is, does the testimony of our witnesses corroborate with both the physical evidence that they had no knowledge of and the other testimony of individuals that they had never met? Because if it corroborates, then we meet that. It becomes reasonable. It meets that reasonableness standard. When you're looking at the reasonableness of the witness's testimony, it's not coming out of left field. It meshes together like a puzzle piece. So how do you view Sam Vigil's testimony in light of Isaac Ramirez's testimony? How do you view Isaac Ramirez's testimony in light of Carla Aguirre's testimony? How do you view Carla Aguirre's testimony in light of Sam Vigil's testimony? Right? When I was writing this, maybe I spend too much time on the internet, but I think of the Spider-Man meme, where all the Spider-Men are looking at each other and pointing at each other, right? They all sort of corroborate, and they all say the same thing. So let's talk about Isaac first. Does Isaac's testimony corroborate with Sam's? Yes. And here's why. You remember the drawing, right? You remember Isaac's drawing that he had given to Detective Hartsock. I want you to look at that drawing and listen to Sam's testimony.
Hello, Lang, what's going on? Somebody shot my wife. Please call the police.
Did it come through the wall? How did it happen?
No, she was driving her car out of the garage. I saw a Jeep. She going to the gym. She was leaving. And when I heard my car honking, I went out there and there was a Jeep that took off. I didn't know what was going on, but I can't get in the car because, it's locked. She's in the car.
All right, so is it in the garage or in the driveway?
It's in the driveway, yeah.
Okay.
Please send the police and
Yeah, I've got a comment. You saw a Jeep that came through, or?
It was a Jeep because I heard the honk in the car. So I went outside to see what had happened. I thought, well, maybe she forgot something. And when I got out there was a Jeep backing up and took off really fast around the corner.
What color was it?
It looked like a brown Jeep to me.
Okay.
But that's all I could see.
And did it go to the left or the right when it left out of your street?
It went out to the left.
To the left?
Okay. Yeah. Please hurry up, okay?
Now, consider that picture. It's very crude, very rudimentary. However, you also have an exhibit of the overhead map of the neighborhood. Huh? There's Isaac's drawing. There's our overhead. This is reasonable testimony, ladies and gentlemen. What Isaac was telling you, he may be a dumb kid. He may be impressionable. He may have gotten in with people he shouldn't have. But his testimony is reliable and it's reasonable. Not because of who he is or what he told you necessarily by itself, but because what he's telling you in comparison with the other evidence all matches up. Right? What about Michaela Gonzalez and David Castro-Aragon? Isaac corroborates their position, right? We talk about the dame la cuete or give me the cuete. I think Isaac said give me the cuete. I think Michaela said dame la cuete. Same difference. He also corroborated the time and place, right? And remember this image of the parking lot at the apartments? And they pointed out, both of them, and they had never spoken to each other, which apartments they had come from, right? Those top apartments there, second story at the end of the row, if you want to look at this like a vanishing point, if you're like an artist, it's at the very end. Up there in the, it would be your top, looking at it, top left corner. God bless you. What about Kayla Smith? Well, we corroborate the Jeep wheel as far as what Isaac told you what happened to that Jeep. And the fact that, hey, she's missing a Jeep wheel from her apartment, from her Jeep at the apartment, which is maybe a mile away or less from where the murder scene occurs, right? So we're corroborating the time, the place, and the proximity to the murder scene, and the physical item itself. What about Carla Aguirre? So Isaac corroborated the conversation after the murder at Noe's apartment. Isaac corroborated the Pacific address Carla testified about. Isaac corroborated Carla's testimony in court about what the defendant said happened when they got to Pacific. Right? At first, the defendant said he crashed into a woman and he had to shoot her. If you recall that, Carla testifying, he wasn't being completely truthful, right? I feel like that's sort of a theme in this case, is people are at least talking a little bit and twisting it just a little bit, especially like on those jail calls. They want to dance around it, but they're hitting certain little nuggets that you can draw out. Isaac asked Carla and Lisa to tell the defendant to tell the truth, right? We heard that from both of those witnesses. And I put this in quotes because this is how I heard it. This is how we heard it. You're to rely upon the evidence and the testimony as you remember it, but this is how we remember it as closely as possible. This is what Carla said. They arrived to, I don't know, a subdivision where she lived. They had gone there because they were going to change a tire on the Jeep because it had flattened. And during that time, a woman was just leaving out of her garage, and he just took the pistol and headed over to her and shot her from behind. That was what Carla said. That was her testimony to you, directly. This is Isaac's testimony to you, directly. But he turned around, he saw the woman warming up the Cadillac, and he told me that he wanted to rob her, and he wanted me to drive the car, or drive the Jeep, and he would take the other car. And I refused because I didn't know how to drive, and I didn't want to rob a woman, and I don't think robbing a woman or doing that stuff. That's how we remember the testimony, right? It lines up. And I specifically asked Isaac, did you ever talk to Carla about this? He said, no. I said, do you ever talk to Carla much at all? He's like, not really. Yet what they're telling you lines up. This is more from Isaac. I told him not to do it, and he looked at me, loaded the gun, put one in the chamber in my direction, and said, don't tell me what to do. Because I grabbed him, and I didn't want him to get out and rob the lady. And he loaded the gun and looked at me and said, don't tell me what to do. He said, don't tell me what to do. He drove forward. He parked right behind Ms. Vigil. He jumped out of the car. He goes to the window, and I hear a honk, and I hear a shot. I hear a gunshot. I hop out, and I see Ms. Vigil's husband, like, everything's happening so fast. Like the honk, the gunshot, and then Ms. Vigil's husband comes out through the main garage door. He seemed to be like he was scared. He had heard the honk and the gunshot, and he sees Luis right next to me in the car, and I told him to go back inside. So that's what he testified to. And after he testified, he was asked on cross-examination about his plea deal. And after he talked about the kind of plea deal that he got, we were then able to talk about his initial interview with Kyle Hartsock, the nerdy commander, if you will, at his home, at the kitchen table, where there was never a plea deal in place, where there was never any promises made, about Kyle just wanting to get at the truth of what happened. And this is what we have.
So a couple things, just want some markers to make it a little bit easier. That night, I wanted to see, will you let me go FaceTime? No, it's your house, man. This is one of those two bugs, so it's fine. Do you mind, to the best of your memory, do you remember what the streets look like, the shape that you're planning out? And then what I want to do is draw the house where the shooting happened at, and then draw where her car was and where the Luis parked the Jeep. Does that make sense?
So I can't remember. So
as best you can.
This is the house, right? This is the house. The garage was right here. The car, I can't remember if it was to the left, right here. And then there was like the street, and then there was dead end. I can't remember if there was like a little curve right here.
Okay.
And I think Luis parked the car, but somewhere around here at first, and then the lady came out, like to warm up the car, I think, and then he pulled right, I think he pulled like around here, and then that's when everything happened, and then that's when her husband came out. Yeah.
Okay. So do me a favor, so put right Jeep number 1 right there, kind of showing where the Jeep was first. And then Jeep 2. Okay, and then where's her car? You could rectangle if you don't mind. Like finish the shape of the car, I know. And then just put just a car. Okay. When you guys, so you saw her out of the car?
Yeah.
Was she in the garage or out of the garage?
I think she was going out through the garage.
So the garage was open?
Yeah, the garage was open.
Was like the light on and stuff?
I think so. I think I remember.
Was it dark or light out?
I think it was kind of dark, though, like everything.
Okay. So, okay, just write your name somewhere on this one real quick. Okay. So in terms of the driveway, I know you said you guys turned, but he was kind of lost.
Yeah, because at that time we were just trying to get out of there.
Okay.
Whenever he crashed the car, that we had to do.
Mm-hmm.
Yeah.
Okay. So you guys turn around, but then that's when you see the garage open?
Whenever we came in, she was there.
Oh,
And
okay.
then he went in and tried to get out, and then like, he took another look. And so there was a woman getting out, not telling her just the couple, but it's a woman. And she was by herself, so I was like, just a couple.
You're saying just take off?
Yeah, I told him to just leave. And like, he told him, no, it's too late. I'm just better than
What did he say when you first saw her though? Like, you're saying, you said just take off, what did he say to her?
She wanted to rock her.
Is that what he said though? Do you remember what he said?
I can't remember really what he said, because like, that night I was pretty drunk and stuff. So.
But he said something.
He said something like, wanted to like jack her or something like that.
Okay.
Yeah. So he just trying to rock her.
And you took it when as robber of what?
Probably for the wallet.
Okay.
Yeah, probably for the wallet, because I told him to go like, not driving the car, and driving cars and stuff.
Had you ever seen Luis like take someone's car with a gun?
Take someone's,
Like steal a car or carjacking?
no, I never saw that, because like, I told him that typically didn't have a license and all that, so like, if I took the road, I was going to get in trouble right away, so I didn't want to do that, so I told him to go with me, but I didn't take the car.
And I want to back up a little bit, because earlier in the night we talked about it last time, but he burglarized the car, right? Like he broke into the car to steal inside.
In those apartments where the people come out.
The people peeking on the balcony or something like that? Okay.
Yeah, because pull out his gun and I stopped him right there, because I told you he was like 3 foot deep in the
He was just...
He was gone. And like, I didn't want him to do that, because it was going to be pretty bad. And like, I pulled him and then I told him, let's get up, let's leave. And then whenever he started like acting up with me,
Even more?
yeah, brought me, hey, what you do?
So we call that a burglary, basically. So if you break into a car or a house just to like steal things inside, a burglary, you call a robbery is when you go to like a person with a gun and you're like, give me your wallet. So that's what I call a robbery. And that's how the law looks at it. So what happened with the car is more of a burglary, but what was going to happen with her that night was more of a robbery, right? The difference is like, it's to a person or it's to a thing.
Well, like the car was on, so I don't know like what he was.
Her car?
The car was on.
Right.
I know if he was doing that, so if you see a car with the keys on, he's gonna try to take off with it.
Have you ever seen them take off with a car?
With a car? No. I never had a chance.
You saw him burglarize a car?
Yeah.
But you ever saw him like steal a car? Did you ever see him rob a person, like besides her? Did you ever see him walk to someone with a gun or threaten that he had a gun and then take stuff from him?
Only that day at the apartments.
When the guy came
When
out?
he pulled out the gun? Yeah.
Okay.
That was the only day I saw him pull the gun to someone.
Okay. Besides that, he just broke into stuff,
Yeah.
right? Like with no one around.
Yeah.
Was usually what he did. Okay. Just notice on this one, again, there's the driveway, there's the car. On my picture, where was the Jeep parked? You used the red.
I think
When he got out, like when he got out of the car,
got out of the car. But like I said, we were somewhere around here, and then
yeah, initially you're over here, right? You turn around.
then I can remember he parked like sideways like that, like kind of like blocking them.
Kind of in front of it,
Yeah.
but not right in front of her necessarily.
I think he pulled up like in front, like somewhere around here.
So she couldn't pull out.
Yeah, so she couldn't pull out. Yeah, I think it was something like that.
Okay. From the time you got out of the Jeep when it's parked, how long does it take before you really got shot?
He went to the window, and I heard him. I can't remember what he said.
He said something.
He said something, but I can't remember what he said. And then maybe like not even maybe like a minute, like 1 minute or like a few seconds, like everything happened so fast. I hear the hum, and then I hear a gunshot. And that's
So what would you guess from the time he gets out of the Jeep to the time you hit the bump and the gunshot? Like, is it
maybe
5 seconds? Is it a minute? Like, you know what I mean?
like 40 seconds almost.
Okay.
30, 40 seconds.
How close is the hump to the gunshot? Is it pretty close?
Yeah, like once you hear the hum,
It's right after.
goes to the boom.
Did he have the gun out the whole time?
Like he had it out, and then he walked to the car.
Like, did she see it, you think, or was he kind of like...
I can't remember.
You know what I mean? Like, you're trying to walk with it,
put it down. He should put it down on the line, so I don't see it. And then once he started fighting for this, though, that's whenever I put it out. But like that day, I told you, like I don't really remember too much. But like, I think he pulled the gun to the window.
Right away?
Like once he heard the hum.
Okay, but that's when he shot though.
Yeah.
But do you think she saw the gun before that?
I'm not
Do you know what I mean?
because I didn't really have that.
Okay, you couldn't tell. Okay. And I kind of cut you off. So he's first here, but you said he actually parks closer, right?
Yeah.
Just saw that with the red.
I think he was somewhere around here. I'm not too sure.
Also kind of pulled into the driveway.
Yeah, so
not even like on the street, like you live there.
Yeah.
Oh. Okay, and you're the front passenger, right?
Yeah.
Okay, so you got like a pretty good view.
I didn't, because like whenever he pulled to the car was like right here, so like the Jeep where I was, it was like right here, and it was like tilted to the side.
Mm-hmm.
So like whenever he pulled to the window, like I think he was, I can't remember if it was black or black, but like the Cadillac was blocking a little bit of the view, so like I couldn't really see the Cadillac. I'm pretty sure he had it in his hand, but like, I don't know if he like, was trying to hide it behind or to the side.
Okay, go ahead and write your name in the red. I'll write my name in the blue since I did the blue.
Next, I want to talk about Carla's testimony. A road trip to San Antonio, Texas, and they broke up the gun when they got there. This is pretty basic, ladies and gentlemen. This is consciousness of guilt, right? We talk about consciousness of guilt. Flight is consciousness of guilt. It's like, okay, I did something wrong. I need to get the hell out of here. Right? That's what this constitutes. Remember the day that they left, the 19th. By afternoon, they're on the road. And going to the tampering, even though they broke the gun up when they got to San Antonio, which is not in New Mexico, the tampering begins when he brings those items to the Pacific address, right? That's when he places them. That's when he takes them. It's a continuation or expansion of that scope of tampering that continues all the way down through New Mexico and into Texas. But don't overthink it. It clearly starts when he goes with the intention of getting rid of these things. And we heard that on the jail calls as well. There's our selfie with the road trip. It looks like fun. And meanwhile, Sam Vigil is living in the aftermath of the worst moment of his life.
Hello? What's going on? What's going on? I can't hear you. I can't understand what's going on. You just shot your wife? Sir, I'm having a hard time hearing you. Somebody shot your wife. Okay. Sir, there's a very loud noise on your phone. I can't hear. Okay. Let me call you right back to see if I can get a better connection. I'm getting off this started now. Hello, what's going on?
Somebody shot my wife. Please call the police.
Did it come through the wall? How did it happen?
No, she was driving her car out of the garage. I saw she was going to the gym. She was leaving. When I heard my car honking, I went out there and there was a Jeep that took off. I didn't know what was going on, but I can't get in the car because, it flopped. She's in the car.
All right. So is it in the garage or in the driveway?
It's in the driveway, yeah.
Okay.
Please send the police and
Yeah, I've got it coming. I've got it coming. You saw a Jeep that came through, or?
It was a Jeep because I heard the honk in the car. So I went outside to see what had happened. I thought, well, maybe she forgot something. And when I got out there was a Jeep backing up and took off really fast around the corner.
What color was it?
It looked like a brown Jeep to me.
Okay.
But that's all I could see.
And did it go to the left or the right when it left out of your street?
It went out to the left.
To the left? Okay.
Yeah. Please hurry up, okay?
Is she awake?
No, I can only...
Do you have the key to that vehicle?
I think I'm going to look for one, yeah. I'll look for one. I think there's another key to it.
Okay, what color is
the car's still running. It's a 2005 Cadillac.
What color is it?
It's black. Please hurry up.
Yeah, they're coming. They're coming. I'm just getting more information for them while they're driving. And is the vehicle in the driveway or in the garage?
It's in the driveway. It's in the driveway. Looking for the key.
Was she moving at all, or?
She's not moving at all.
Okay. She slumped forward, backward?
She slumped. It looks like she slumped backwards.
Okay.
Or to the side anyway. To the side. Okay. That's all I can see.
Where was she bleeding at?
I can't tell. It's too dark for me to be able to tell.
Okay.
I think.
Do you have something?
Should I open the car? Should I open the car?
Yes.
I found the key.
Yes. See if she's breathing. See if she's breathing. See if she's got a pulse.
Okay.
Is there a bullet hole in the window
I
or
can't.
the door?
I can't open. No, I can't open the door. Oh my God.
Try the other door. Did you hear a gunshot? Why do you think she was
Well,
shot?
I can see the bullet. I can see the bullet, the hole in the window. Oh, I can't open it.
Okay.
Yeah. Oh my God. Please,
Okay, we're coming, we're coming. What side is the bullet in?
It's the driver's side. Oh, no. No. Please.
What's your wife?
She's 55.
55? What is her name?
55, Jacqueline.
What's the last name?
Jacqueline Vigil. Jacqueline Vigil. Yeah.
How do you spell
man. Jacqueline.
Okay.
She's Vigil.
Okay. What is your name?
My name is Sam Vigil. I'm her husband.
Sam. Okay. So did you hear any gunshots?
I didn't hear anything. I was, she went out. She says, I'm going to the gym. She goes to the gym every day. And I said, fine, I kissed her and she went out the door. And actually, I opened the garage door for her and the car door because she had some, she eats a lot of fruits and stuff.
Mm-hmm.
And then she said, okay, I'll see you later. So I walked back in the door. And after a little bit, maybe 30 seconds or so, I heard the car honk.
Uh-huh.
And I thought, well, maybe she forgot something, wants me to get you some water or something. I went out there, and I saw this Jeep on the back of the car.
Uh-huh.
And when they saw me, they took off, or, I couldn't see if there were two, I don't know. Maybe
When they saw you come out, they took off? Was there somebody out of the vehicle?
No, there was nobody out of the vehicle, so I'm thinking that they probably shot from inside the vehicle, I would think. And there's a big bullet hole.
Okay.
Please hurry up.
Yes, they're almost there. They're almost there. Stay on the line with me, okay?
Mm-hmm. I can't find the key to open the door.
Okay. Do you have something that maybe break the glass?
I guess I could. It doesn't work. Can't find the darn key.
Can you remember anything else about that Jeep? It was brown. Did it have a soft top or hard top?
Yeah, it was. I think it's one of those Cherokee. It looked to me like a Cherokee.
Okay.
It's a hard top. It wasn't.
Okay.
Like a. Yeah.
Okay.
Please hurry up.
Yeah, they're almost there. They're almost there. They're almost there. Any bumper stickers, damage on that Jeep?
Why would anybody do this?
Sam, listen to me. Listen to me. Anything you can remember about that Jeep so we could try and find them? Any bumper stickers, vehicle damage, rims?
I couldn't see that. No, it's too dark.
Okay.
Too dark. Oh, no, come on. Come on.
They're almost there. Are you outside? Are you in the vehicle? Could you tell me if she was breathing if you just looked at her? Could you tell if she was breathing? Like, was her chest right?
I don't think she's breathing. I don't think she's up there on the car.
Okay.
Oh, come on, hurry up, man.
They're almost there, friend.
Oh, God, why would you do that? Oh, no.
Yeah, I've got everybody coming. The officers are listening. We've been on the phone 7 minutes now. We've been on the phone 7 minutes. All the officers are about there, okay? Do you want to just go outside and wait for the officers?
I got 10 doors open so I can keep them in.
Okay.
Oh, man. No. Oh, my God. Thank you.
Did the fiance
I
get that?
want somebody shot my wife.
Okay.
Okay. I can't look up my fucking keys.
There's a casing right here.
The first, she's bring on this side here when the shut when the.
Do you guys own any firearms?
Is anyone else inside the house?
Yeah.
Nobody else?
Do you guys own firearms?
No.
No. Okay.
I can't find the keys to the car.
Okay. Do me a favor and stay over here for right now, right?
Can we get some help for my wife?
Can you hear me?
Why would somebody do that? Why? She doesn't.
Was she going to work?
She's going to the gym.
To the gym? And you heard the shot?
I didn't hear the shot, but she hooked the horn or somehow, so I came out and I thought that she.
You can hang up if you didn't hang up yet. Sorry.
I came out.
Huh? Not yet.
When I came out, I went to the window because I thought, well, there was a Jeep, a brown Jeep behind the car.
Okay.
When they saw me come out, we backed up and left here.
Okay, so I want you to be very careful because I want you to step on this casing that we have here. Okay? See this right here? I want you to step on that, okay?
Oh my God, I didn't see.
Yeah.
Why would they do
And
that?
do you have extra set of keys, sir?
I can find them. I haven't realized because they didn't work.
Okay.
I want to leave you with this. I want you to juxtapose that, what you just saw, with what Luis told his nephew on jail calls. Was it someone we knew? Thank you.
Yeah, before we get to closing argument from defense, there's a portion of the jury instructions I have to read. What is said in the arguments is not evidence. It is an opportunity for the lawyers to discuss the evidence in the law as I have instructed you. And so, Ms. Reinhardt, closing argument.
Yeah, Jesus Christ.
Oh. Yes.
Okay. Okay.
Yeah, yeah.
What? Oh. What is this?
It's the microphone for the
Okay.
headphones.
Okay. Ladies and gentlemen of the jury, can you hear me? Okay? All right. Judge Bacamiller, counsel, Mr. Talamantes, and Mr. Vigil. This is a sad story. This is a sad event. And no one can listen to that 911 call without feeling a great deal of emotion. I feel it. We all feel it. And we all have sympathy for Mr. Vigil and Mr. Vigil's family for what they've gone through. But we have to look at all of the facts in this case and all of the evidence in order to get a true sense of what happened on that night on early morning of November 19th, 2019. I want to start, and just if we can maybe calm it down a little bit here. I want to talk first, before we get into the other details, about the police investigation. In this case, we had an initial investigation that was conducted by Mike Luna, Jose Lucero, and Rick Ingram. None of those people testified in this trial. And what we learned is that there was a period of time, approaching 18 months of time, from the incident that happened with Ms. Vigil to the time that it was picked up by Carl Hartsock, who at the time worked for the district attorney's office. So there was this long period of nothingness really happening. And with all due respect to the Vigil family, they were left hanging, wondering what is going on with this investigation. At some point in that, perhaps March of 2021, Detective Jesse Carter was asked to review what consisted of the file that had been constructed in this case. And he spoke to you today, and very briefly, because he was not on this case, he told you that he had investigated hundreds of homicide cases over the course of a 49-year career in New Mexico and Texas, and in fact had a 97% success rate in his investigations. And he didn't want to take the case over. In fact, he was ordered to take over the case by his superiors, ordered to review the case. And he said, I'll review it, but I'm not going to take over the case, and I'm not going to be affiliated with this case. I don't want my name near it. That's a pretty strong statement for one law enforcement officer to say about an investigation in his own department. Then in March of 2021, Carl Hartsock, who had approximately the experience of about 6 homicide cases, took over the investigation. And he, in fact, was working for the district attorney's office at the time that he began that investigation, and continued in that role throughout the beginning stages of the investigation that involved his interviews with Isaac Ramirez. And I think we tried to point out through his interviews of Isaac and throughout the course of the investigation that he was kind of subtly threatened to cooperate with the investigation and cooperate with the DA's office by comments that he would make, like we didn't, questions about Isaac's parents or his mother or and their immigration status, and questions about how his sister was doing in school, and it would be nice if she could complete her education. And I think the clear message that was conveyed to Isaac was, you better work with us and you better work to help us convict Luis Talamantes. So you better comply. And what happened and what the end result was that Isaac entered into an agreement with the state. We have our one Exhibit A, we'll send back to the jury room with you, that indicated that Isaac would serve no more than 7 years or be on probation in exchange for giving the district attorney's office the information that they felt they needed in order to prosecute this case. And what you will, if you will refer to Exhibit A that we have, the sentencing agreement was that sentencing, he still hasn't been sentenced on this case because they're waiting to see how he did in this trial. So sentencing was to be held in abeyance in order to ensure that the defendant remains in the United States to be available to give a statement and testify truthfully in the state of New Mexico versus Luis Talamantes-Romero. In addition, the state agrees to apply for significant public benefits parole through the Department of Homeland Security. The decision of whether or when to deport the defendant rests exclusively with the Department of Homeland Security, and the state makes no promises with respect to sentencing. And he executed this about 2 months after he was first interviewed by the district attorney's office. And part of his deal with the state was to basically do what he could to convict Luis Talamantes. And the factual basis that they put into the plea agreement I would like you to review. And he was, by virtue of this agreement, trying to save himself from the consequences of his actions. I know that Mr. Duran mentioned on his closing that the evidence was, if you recall, the incident that occurred at the Mesa Ridge Apartments. Mr. Duran indicated that the evidence was that Michaela Gonzalez and Daniel, I hope I get his name right, I think it's David Castro Aragon, had testified that it was not Mr. Talamantes who was out roaming around the vehicles in that parking lot, but in fact it was Isaac. And there's a couple of things Isaac says throughout even his testimony here today, or this past week, and that is basically, I really care for my family, and oh, by the way, I was always in the passenger seat because I didn't know how to drive. And both Michaela Gonzalez and David Castro indicated that they saw, they said they couldn't ID the people in the car, but they heard the phrase, "Give me the gun," dame el cuete, I guess. I don't want to embarrass myself with the Spanish I have, but give me the gun. And that was by the passenger who'd gotten out of the car. And Michaela Gonzalez testified to that fact, as well as David Castro Aragon. So the person who was out rummaging through the Escalade and getting out of the car was not Mr. Talamantes. Mr. Talamantes was in the vehicle, and Mr. Ramirez was the one that was out burglarizing that vehicle. And the evidence will show, and I believe it has been shown in this case, is that Mr. Talamantes and Mr. Ramirez were quite intoxicated, high on drugs, and acting pretty irresponsibly. That's correct. So basically what we have is that when the first indication that there was something going on at those apartments was when Michaela Gonzalez woke up David Castro and said that she'd heard something, and she said there was a guy in the front seat of the Escalade, there's a guy on the driver's side of the Jeep. And so they called the police about 4 o'clock in the morning, and the cops show up a few minutes later, and both Mr. Castro, Aragon, and Ms. Gonzalez saw the person in the Escalade, and they believe that there was 2 men, but they see a guy out of the Jeep from the passenger side who approaches the Jeep and says, give me your gun, give me your gun. Which means that it was Isaac, not Luis, that had the gun at the point where they were in dealing with the when that event was happening at the Mesa Ridge Apartments. And it was the guy, and David Castro Aragon indicates that it was the guy from the passenger side of the Jeep who in fact pointed a gun at him. And so the testimony from him and both Michaela, who says she heard the passenger say, "Give me the gun," in Spanish. So at the point that they were at the Mesa Ridge Apartments, it was not Luis, but it was Isaac who was in the passenger side, as he was very insistent upon pointing out, and he's the one that had the gun. And we would submit to you, ladies and gentlemen, that this whole issue about the... Do you have the photographs? I think this is the first image. I hope I can get this to work correctly. So the vehicles pointed out there in the State's Exhibit 1, and you can see there, it's not the best copy, but unfortunately it doesn't show who was driving and who was the passenger. But I'd like you to take a look at that when you're in the jury room. Likewise, this image, which was on surveillance camera, which appears to show a vehicle similar to what has been described in this case. And if you notice, it's very hard to tell by these photographs what the rims look like, but they appear to be pretty shiny and somewhat like chrome. And that's both exhibits, State's Exhibits 1, 2, and 3. Likewise, the state produced an exhibit of a photograph that was identified as Luis in that vehicle, and you see those rims on that car are pretty large, and they are, in fact, chrome, it appears. So these are the rims of that vehicle before anything happened. There's not a date on this, as I recall, but it's before the time of the Ms. Vigil's murder. That's Exhibit 9. In Exhibit 101, you can see this is at the Pacific address. Those rims are still there, still on the vehicle. Same with Exhibit 107. You can see that vehicle parked, and Exhibit 109. And here's another photograph of exhibit of the car, Exhibit 110. So if you take a look at these in the jury room, ladies and gentlemen, the vehicle, it's the same rims before, it's the same rims after. So this whole thing about them stopping in this apartment, there's no report, there's no evidence other than Kayla Smith coming in and saying, somebody took my wheel on my car. She didn't see who it was. There's no evidence that indicates that Luis or Isaac were there or that they stole anyone's tire. And I would also like to point out that in Andrea Ortiz's investigation, in her part of the investigation, she has investigated hundreds of cases, and I've dealt with her many times before, and she's, I think, a consummate professional. And I'll give credit where credit's due, and she's quite a good criminalistics detective. But she points out, and we asked her about this next exhibit, Exhibit 25, which is a completely different kind of wheel. It's a completely different kind of rim from what was on the car before, the Jeep, before and after. And I asked her, I said, does that look like that was thrown to you? Because there's no movement of rocks around it, no movement of leaves or anything that looks like something that might have been flying. And if you recall, Isaac testified that he reached over and picked up this tire and rim that must have weighed 60 pounds or so, and threw it out the door. There's no indication that's been tossed there, and even Andrea Ortiz indicated it looks like it was placed there. And it's curious that it was there practically in the backyard of the Vigil home. As you see, here is the backyard area of, in the top, I guess, the porch of the Vigil home. And it's like, why would you leave a tire there as almost like a business card saying, hey, I was here. So it's our contention, ladies and gentlemen, is that there was never a change of tires, never a change of anything, and that the whole Kayla Smith incident was something that was attributable maybe to somebody else who was burglarizing, but it wasn't indications that it was Luis or Isaac. And I think it's indicative that these two drunk guys were trying to change a tire. They might have left a fingerprint or two, but Andrea Ortiz will tell you that there was absolutely no latent fingerprints that they were able to get from that wheel, very flat surface, and that there was certainly no DNA. So there's no evidence that either of these guys actually had anything to do with the stealing of that car tire. And I think it just goes to the credibility of Isaac also. So, and plus it makes no sense in the middle of the night. And the whole thing about, then we were driving over by Home Depot and we cracked the wheel. None of that makes sense. And you're driving around in a Jeep with 24-inch rims, and then all of a sudden you put a much smaller tire on. I don't think that happened at all. But Isaac Ramirez is trying to help the state link somehow that event with the rest of this case and the theft at the Mesa Ridge Apartments, and then that which occurred, the murder that occurred at the Vigil home. So I want to have you also look at this is this diagram we've seen a couple of times. Didn't realize this was going to be so important, but clearly Isaac describes the Vigil incident where the Jeep's here, then the Jeep's there, and the car's here, and he puts Luis over here next to the car. In the garage, however, that is where actually Isaac was in that garage, and he's placed himself in that garage. There's no evidence that Luis was ever in that garage. The testimony was that the evidence in the case was that the car had been in the garage and she was pulling out, and the car was all the way out of onto the driveway when apparently the shot took place. And Isaac puts Luis here next to the window and himself in the garage, and he's the one that stands close to, as Andrea Ortiz indicated, next to the trash bag there with the casing that is right there. And as she had testified, if the gun that he had, and he had it because he'd had it over at the Mesa Ridge Apartments, and he still had it when he went to the Vigil home, and it was Isaac that was in that garage, and he shot with the ejection pattern being such that it would always go to the right, and that with that particular gun, and that's what Andrea Ortiz testified to. So that would explain why that casing is in the garage. If in fact Isaac was here, the casing would make sense that the casing would be next to the, as in Exhibit 80 shows, the casing is next to the file cabinet and bookcase there. So there's no evidence that Mr. Talamantes was ever in the garage at all. And we submit that in this case, the state star witness is in fact the killer in this case. And he has done whatever he can do to get himself out of the mess he got himself in, and he's taking Mr. Talamantes down with him. I would suggest that you think about the credibility of Isaac and his motivation to lie, his motivation to make the district attorney's office happy or the police happy with his testimony so he can be protected and walk away from this incident. His concern for his own future is motivating him to say whatever negative things he can about Mr. Talamantes. So, with respect also to Mr. Ramirez, he said several different times on the stand, he said, in response to questions from the state, he says, I don't want to say yes, but I don't want to say no. And I think that's a very revealing statement about, I know what the truth is, but I don't want to tell it to you because that's going to hurt me somehow. And I think you need to take his comments into consideration when evaluating his credibility. And I heard with respect, maybe I misheard it, but I thought that Mr. Duran said something about Ms. Vigil being out of the car. I don't think that there was any evidence of that. And with respect to the robbery charges and the burglary charges, first of all, there's no evidence that Mr. Talamantes was robbing. I mean, the vehicle was locked. He couldn't get into it. He wasn't trying to steal it. He wasn't trying to get into it. And there's no robbery that took place here. There's also no burglary that took place. So we'd ask you to consider that likewise. And it's kind of it's sad looking at these photographs of Miss Vigil, and bless her heart, you know, it's just very sad, but it appears that she was, and OMI said this as well, that when she died, she apparently had her foot on the brake as the vehicle was in the driveway. And I think that's important to note too, that did not occur in the garage, it was in the driveway. And the only person in the garage was Isaac Ramirez. I want to address a little bit about the home over on Pacific Avenue. Apparently this was a home where Luis lived. Isaac Ramirez was over there all the time. So was his sister Elizabeth, his nephew Ricardo, and Isaac Ramirez was there. I think he was just a little punk at the time, and I think he was trying to be something more. And was hanging around, obviously, with places he shouldn't have, but he's the one that had the gun from Mesa Ridge. He's the one that had the gun at the Vigil home. And it's not surprising, since he also lived at the Pacific address as well, and it was there all the time, according to testimony from not only Carla, but also himself, is that the casing, which had the same characteristics as the casing over at the Vigil home, there was a match. And as mind-numbing as the testimony was for me, at least, on the ballistics, it's pretty clear that it was the same, the casings reflected from the same gun. But that's where Isaac was in both locations. And so that would explain why that same casing, that same type of casing, and the characteristics of that casing existed in both locations. With respect to Carla Aguirre, she had had a relationship of some duration with Luis. She also lived at that location with Elizabeth and Luis and Ricardo. And I think it came out on her testimony that she, in fact, was given money in exchange for her testimony as well. And the
Yes.
So Carla did have her expenses paid, and I think we have another photograph here. I think you've seen it probably enough if I can't find it, where she is certainly on the trip to San Antonio. Do you have that? You've seen it before. It's okay. You've seen it before, but they're all three of them are traveling to San Antonio. And she doesn't appear to be coerced. She doesn't appear to have been kidnapped. She doesn't appear to be stressing at all. And that's in the exhibits you're going to be able to look at. So she is making statements to the I think it was the FBI. She was doing an interview that was recorded, and she had concerns about immigration issues as well. So I think that her statements about what Luis said or may have said about what happened on November 19th need to be taken in context of what what her motivation was, whether it was some retaliation for past events in their lives or whether it was for concerns about her future, her own future. Also, there was evidence the state submitted that I think from that Pacific address there was photographs and testimony about a roof rack being removed from the car's hood or the top of the car, and if we look back on the photographs that from before the incident and looking at what's there from November 19th, 2019, if you look at that vehicle, there's no roof rack on that vehicle. And I think one of the charges that Mr. Talamantes is dealing with is he's being accused of tampering with evidence because of the removal of roof rack on that car that clearly wasn't in place on the night of the incident. So I want to just address some of the jury instructions with you for a moment. I know it's been a long afternoon, so I'll try to move along here, but as I said before, there's no evidence that there was actually a burglary that took place here. Clearly, Ms. Vigil's death is incredibly sad and horrible and everything, well, it's just horrible. But with respect to evidence of an attempted or even a completed aggravated burglary, there's just no evidence of that. Mr. Talamantes wasn't in the garage. He wasn't trying to rob her. There's no evidence that he was even out of the vehicle, although there's evidence that Isaac was. With respect to those particular jury instructions, I think they were jury instruction 19 and jury instruction 25. I'd ask for you to take a close look at that so that there's due consideration for that. There's no evidence that he tried to carry away a Cadillac or anything from inside the Cadillac. And that's instruction number 25. In this situation, in this case, we have an individual who's being charged in this case that he's still, as he sits here in this table this afternoon, he's still an innocent person. And he's not guilty until he's proven guilty. And the state has to prove that. And you have to weigh the credibility of Isaac. You have to weigh the credibility of Carla Aguirre, both of whom have motivations to have bias in their testimony. So please do that. Instruction number 7 indicates that you are the judges of the credibility of the witnesses and the weight to be given to their testimony. In determining the credit to be given to any witness, you should take into account their truthfulness or untruthfulness, their ability and opportunity to observe, and the manner while testifying, any interest or bias or prejudice the witness may have. I think the interest and bias may go to Carla Aguirre's testimony. The self-interest of Isaac is certainly something to consider when you go in to deliberate. And the state has to prove with concrete evidence. They can't prove it with suppositions and innuendos as to what happened in this case. And there's a lot, as sad as the emotional part of this case is, and it's very emotional for all of us, when you get down to it, the evidence is very thin. And you have to weigh that with respect to each one of these charges. And the state has to prove every element of every crime that they are charging. So you'll see this all laid out in the jury instructions, where you have all of the elements, and each element has to be proven beyond a reasonable doubt. Okay, let's see what else I have here. The other thing, before I get to the last part of this here, the verdict has to be unanimous. You all have to agree with respect to every jury instruction here. And I think we talked a little bit about if one person feels one way and the other 11 feel a different way, can you withstand the pressure and the peer pressure to not change your vote? You have to be able to, each juror's decision and feelings and decisions with respect to what needs to be done in this case you need to hold fast if you are that one person or in a small group. With respect to the first degree murder instruction, which is instruction 12, if you do think that Mr. Talamantes has something to do with this case, I want you to pay close attention because to instruction 12, which says the word deliberate means arrived at or determined upon a result of careful thought and weighing of the consideration for and against the proposed course of action. A calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not a deliberate intention to kill. And it appears from the facts that if you were to find Mr. Talamantes was the one who pulled the trigger, which there's not any real concrete evidence of in this case, I submit to you, you have to look at the context of what happened in a split second, a couple of moments in time, with someone who was apparently drinking, apparently on drugs, and not able to form an intention that the jury instruction 12 requires. Jury instruction 13 says an issue you must consider in this case is whether the defendant was intoxicated from the use of alcohol or drugs. You must determine whether or not the defendant was intoxicated from the use of alcohol or drugs, and if so, what effect this had on his ability to form a deliberate intent to take away the life of another. And what we've heard from the testimony is that this is something that happened in seconds, that there was some reason for Ms. Vigil to have laid on her horn, she honked, and there was a gunshot. The question is, who did that? And you have to, and if you were to presume that it was Mr. Talamantes, you have to look at his state of mind and his intent, if that's where you're leaning. And it's pretty clear, I think, from the evidence that we do have, is that at best this would be a rash impulse. It's something, a reaction to the horn being honked or something, but there was no intention to kill her. There was no plan to kill her. And there's absolutely no evidence of that whatsoever. So I would ask you to keep that in mind as well. I'm going to try to wrap it up here. So I just appreciate, this has been a long trial for all you guys, and I appreciate your patience and the million bench conferences we've had, and I appreciate your attention to the trial, and on behalf of my client and our side over here in the defense team, I appreciate your attention and time. And good luck with all of this. So thank you. I'm going to take the rest of them. Okay.
Rebuttal, Mr. Dren?
That's it.
Or do you, I think we may actually, yeah, I think a break would actually be a good idea since it's 4 o'clock. And that means that you can all be outside. And so we'll take about a 10-minute break. It's 4 o'clock. Be ready to go at 4:10. I'll rise for the jury. We're off record. You may be seated. Rebuttal, State.
Thank you, Your Honor. Ladies and gentlemen, we're almost at the conclusion of this trial, and I know that you have been presented with a lot of evidence to consider. Despite what defense keeps saying, that there's just no evidence, there's just no evidence, there's just no evidence. In fact, there is a huge amount of evidence in this case. I'm not going to reiterate everything that Mr. Duran went into because I know you're anxious to get back there and start deliberating, but there are some highlights and some rebuttal that I would like to present to you. Let's start with the argument that law enforcement is just really unfair and had this unfair laser focus on this defendant. Let's talk about what you heard from Commander Hartsock. At the time that he took over this investigation in the summer of 2020, he was a special agent in charge at the district attorney's office. For clarity, let me just clarify what Ms. Reinhart said. Detective Carter reviewed this case in March of 2020, not 2021. So Detective Carter takes a look in 2020, and months after that, it goes to Kyle Hartsock. He gets the entire file. He gets everything. He said, and he told you, there were some things I wanted to do. I wanted to follow up here, I wanted to follow up there, I wanted some phone records. I looked through everything, I dumped everything, and he did follow up. He told you, I just follow the evidence. He started fresh set of eyes on this case. He talked about what that meant to him. He said, I look at physical evidence, which can mean statements, but ballistics, social media, phone records, it's always going to get you closest to the truth. He's the one that located Isaac in the fall of 2020. He's the one that located the jail calls where you can hear this defendant talking about the murder. And then you hear his family talk about tampering with all the evidence of the murder and getting him out of town. He sent Agent Iglesias to interview Carla, which also happened in the fall of 2020, resulting in that very important selfie with the date stamp of November 20th of 2019, one day after Jackie was murdered, showing this defendant fleeing Albuquerque, not Isaac. Commander Hartsock told you he reviewed everything. He started over. And everything he reviewed and everything he testified to gets us to this defendant. Now let's talk about Isaac. Defense has pointed the finger at him because that's what they have to do. We know the two of them were there. Let's talk about Isaac's credibility. Isaac's not the reason that this investigation became focused on this defendant. The defendant's sister is the reason that this investigation became focused on the defendant. She had that car in her yard. It's a distinct car. It's on the news. They're looking for it. What's she gonna do? They're gonna dress it up. They're gonna change the wheels. They're gonna take the roof rack off. They're gonna take the front panels off, the most distinctive part that you can clearly see. And then she's gonna turn it in. And Kyle Hartsock told you she gave them a list of names. Ghosts. Vague names that when they tried to follow up didn't really lead to anyone. She's trying to get rid of that car and steer away from her brother. Steer that investigation towards a ghost. Let's talk about what Commander Hartsock said about Isaac. He knew things from that night that weren't public. Everything he said, that drawing that he made, lined up with what happened, with what Mr. Vigil testified to, with what the 911 tells you, with what the first responder lapels tell you, with what that track through the gravel tells you. He told Detective Hartsock, Commander Hartsock, he told him exactly what happened. But not because he's the shooter, and we'll get to that in a minute. Let me clarify something else. Part of his deal, and you have his plea in evidence, you can take a look at that, was not to convict the defendant. Read it. It says you're going to testify truthfully. And let's think back too. You heard testimony not only from Isaac, who sat here under oath on the stand and told you what happened, but you heard his previous statement before he ever got any deal. He hasn't been sentenced. He doesn't know what he's going to be facing. But his statement, the first statement to Commander Hartsock, There was nothing on the table. He didn't have any promises made. Commander Hartsock told you, I can't make a promise. I don't have the authority to give him a deal. And that first statement was consistent with what you heard on the stand. You also heard from Commander Hartsock that he gave more than one statement. He went back to his apartment, talked to him a couple times, and that across the board, Isaac remained consistent with what happened. Now, defense was critical of him saying, I don't want to say yes, I don't want to say no, but you're the judges of the credibility here. You get to think about how he was on the stand, if he was nervous, if he appeared to be just really trying to earnestly tell you the truth. I don't want to say yes and no, I don't remember. He wasn't trying to dodge the truth. He was trying to be honest. He was trying to give the complete story. He was trying to not guess. And he was consistent with what he told Commander Hartsock back in 2020. Now let's talk about, did he do it? Let's start with Mesa Ridge. Let's talk about the testimony from David and Michaela. There was a lot of argument about what David and Michaela saw, who handed who the gun, but the basic facts are neither David or Michaela saw that Jeep drive up. Neither of them could ID anyone. Neither of them saw the Jeep drive away. And Isaac was asked, did you get in the driver's seat? And he said, I don't know, maybe, I don't know. Did he slide over to hand the gun? Did he sit there while the defendant robbed the Escalade? All of those things are on the table. What we do know is that Isaac did not have a driver's license. He told you that. He told you he didn't know how to drive. No one ever taught him. Commander Hartsock told you he didn't have an ID. He ran him. He was hard to find because he didn't have a driver's license, corroborating Isaac. This was the defendant's vehicle. You heard from Carla. It used to be driven by other family members, and then once the defendant came to live at the Pacific address, it basically became his Jeep. You heard him talking about that Jeep on the November 12th call to his nephew Eric, about the things he was going to do to it, the oil change. That's his car. He's not letting Isaac drive it. He's in charge this night. Did Isaac do it? Let's talk about Jacqueline's murder. Let's think about Isaac. Well, we know that he's given consistent statements. And let's think about the defendant. What do we know from him? Well, we know on the day Jackie was shot in the head, he got on the phone to his nephew, and you heard that call multiple times. I fucked up. Not Isaac fucked up. Not I was there. Not I saw something terrible. I fucked up. He shot Jackie. Then he tells his girlfriend, and we heard her testify, Carla, the day of the murder, that morning, he goes home and tells her, oh, you know, I wrecked the car and then I shot at a woman. Close to the truth, sort of. Part of the truth, not the whole truth. But Carla told you she kept talking to the defendant later and later, and at that first admission that he made, Isaac was there, and he turned to Carla and Sister Liz and said, you need to tell him to tell the truth. And he did later. And Carla told you she talked to him not twice, not multiple times. Here in Albuquerque, after he was in San Antonio on the phone, and he later gave her a much more consistent story with the truth, that the woman was leaving out of her garage, and he just took the pistol and headed over to her and shot her from behind. It's pretty close. He didn't tell her, Isaac shot this woman from behind, or someone else shot this woman from behind. He told her he did it. And Isaac wasn't there, those later calls and conversations with Carla. Isaac was there for the first time when he said, he needs to tell the truth. He told the truth later, after he fled to San Antonio, while Isaac was still here in town. He never once blamed Isaac, but he did tell Carla, you better not tell anybody about this. Let's think about the defendant's family. His sister, Elizabeth, sometimes goes by Liz or Lisa. His nephews, Eric and Ricardo, and other family members that are sort of unnamed in the jail call, but we hear them kind of talking about different people. They're helping the defendant cover this up, not Isaac. Isaac told you, hey, I knew one of the nephews from back before, but then I started working at this restaurant, and it was a couple months before the murder. I met the defendant and Liz, and I started going to the Pacific House. Isaac's not family. Liz and Eric and Ricardo are not going to cover up a murder for Isaac, this kid that they met 2 months ago. But you know who they are going to cover up a murder for? Their brother, their uncle. They hid his Jeep. You hear the jail call, they put it between two paths. Carla told you they moved that fence, put it between the two houses. They dismantled that Jeep. They destroyed the gun. Not just any gun, the murder weapon. You heard testimony from Carla. He had other guns. He didn't take other guns with him to Texas. He took that gun to Texas so they could get it out of here, break it into pieces, and throw it out the window for him. And she testified that he helped break it into pieces when they were down in Texas. She could hear it, and she saw it after. His sister and his girl drove him to Texas. They didn't drive Isaac to Texas. He stayed here. They drive him to Texas to get him out of here. And you hear his sister on that call. We gotta get him out of here. By tomorrow, everything will be okay. Gotta get him out. And then you hear Eric say, you gotta hide the truck. It's already done. They're not covering anything up for Isaac. They don't care about Isaac. They don't know Isaac. They know him. They clean that Jeep and they talk about how they better get it really clean. You better get it real good. Clean it inside and out. You heard testimony about the defendant being violent from Carla. Let's talk about this idea of intoxication. The defense has kind of said, well, Isaac did it. But if the defendant did it, he was just super drunk. So it's not even his fault. And he was so drunk he could not have formed the intent. But let's think about the actual evidence of intoxication that we have. Let's think about the area of town we're in. So we know that they're driving around in the defendant's Jeep. They're hitting the west side. We start over at Mesa Ridge. We're breaking into an apartment there. You heard from Michaela and David. It was their apartment. Then they're going to break the tire somewhere down near Coors and I-40. When I say they, the defendant's driving. And now they need a new tire. So they're going to go to the Ladera apartments where Kayla Smith lived. But let's start with Mesa Ridge, with Michaela and David. Let's think about this robbery. Let's think about how this Jeep, you saw the maps and you have them in evidence, drove in through the entrance, turned around so it's positioned to leave. You hear how the defendant is able to get out of that car, be confronted by Michaela and David, get a gun, point it at David, who then goes in. He's not panicking when he's caught. He's not freaking out. He's not falling over drunk. It's controlled. Go back in. And David did. Michaela did. He went back in, got the kids, put them in the bathtub. This isn't an out of control situation. The defendant was in perfect control. He didn't even stop burglarizing the Escalade. He got the gun and continued about his business. Let's talk about this broken tire. So we know that after the Escalade is burglarized, they're driving around. Isaac says they just kind of drive all over the place. They get on I-40, they come off, they exit Coors going north, and he takes a turn really fast. He's driving crazy, and he hits that curb, and he breaks the tire. So now he needs a new tire. Now we have a disabled vehicle, right? If the tire's not flat, it could be at any moment. So let's think about this in terms of intoxication. Isaac did tell you, we were drinking, we were doing some drugs, he might have been on some pills. But let's think about Mesa Ridge. And now let's think about this broken tire situation. Isaac told you they go to one apartment complex, didn't find the right Jeep. So he's lucid enough to know what kind of car to look for. Drive to a second place. Find the right Jeep. And Michaela told you that Jeep, she was showing a picture of the defendant's Jeep, looks just like mine. That was just the kind of Jeep I had. Now, together, Isaac told you I was sober enough to change a tire. Well, so's the defendant, because he's overtaking the tire off of Kayla's Jeep at the same time. So they're both able to do some mechanical work at this point, and this is between 4 and 5 in the morning, and we know that because Mesa Ridge happened around 4 a.m. and the homicide happened around 5 a.m. So this tire business all happened within that hour. So within the hour of shooting Jackie, he's able to locate just the right Jeep, get out, change a tire, and they don't just leave Kayla's car, you know, with one tire down. They put it up on blocks. They left it nice for her. These aren't the actions of someone who's out of their mind, who can't form intent. This is, again, a clear-headed moment. We have to fix the car. So we do. Now we're back on the road. There's been discussion of, was this placed here? And Andrea Ortiz was asked, yeah, I mean, it looks placed. And then she was asked on redirect, do you really know if it was placed there? No. She wasn't asked about buoyancy of a tire, if tires bounce, how physics works. But what we do know is if we look at this, compared to the tire tracks created by a 2-ton Jeep as it peeled out, hardly any gravel's disturbed there. Do we really think a tire getting rolled out of a car is going to disturb this compacted gravel in a neighborhood from